722.23. If the DA makes a motion to prevent removal of an adolescent offender's case to the family court, such motion shall be noticed to be heard promptly. Notwithstanding the provisions of subdivisions 2 and 3 of 722.20, the court shall, at the request of the district attorney, remove an action against a JO to the family court if it is determined that to do so would be in the interest of justice. However, where the felony complaint charges the juvenile offender with murder in the second degree, rape in the first degree, criminal sexual act in the first degree, or an armed felony, such determination shall, in addition, be based upon a finding of one or more of the following factors. 1. Mitigating circumstances that bear directly upon the manner in which the crime was committed. Or 2. Defendant's role was relatively minor, although not minor enough to constitute a defense to prosecution. Or 3. Possible deficiencies in the proof. So that's the MARC, M-A-R-C, murder second, rape first, criminal sexual act first, armed felony. Which of the following is an adolescent offender? Nicole, 16 years of age, charged with unlicensed operation of a motor vehicle, a traffic infraction, allegedly committed when she was 15 years of age on October 4th, 2018. So that is a misdemeanor. So she was 15 and committed a misdemeanor, so she is not criminally responsible and therefore not an adolescent offender. Also, it's based on the time that you committed the offense. So she was 15 when she committed the offense. So even if that was a felony and it wasn't in the BTL, then she would still not be an adolescent offender. So John, 17 years of age, charged with 511-1, a misdemeanor in the BTL, allegedly committed when he was 16 years of age. That is, again, not an adolescent offender because he was 17 years of age, which is okay, but he was 16 years when he committed it, and it's a VTL. So that would be a person ending up in regular criminal court. Angela, 16 years of age, charged with murder in the second degree, allegedly committed on October 1st, 2018, when she was 16. So that is an adolescent offender. Karen, a 16-year-old, charged with petty larceny, a misdemeanor in the penal law, committed on October 2nd, 2018, when she was 16 years of age. So Karen is not an adolescent offender or juvenile offender or going to criminal court. Karen is going to family court because she's an alleged juvenile delinquent. 722.23. Following the arraignment of a defendant charged with a crime committed when he or she was 16 or commencing October 1st, 2019, 17 years of age, other than any Class A felony except for a drug felony, a violent felony, a juvenile offender felony, or an offense set forth in the BTL, the court shall order removal to the family court unless within 30 calendar days of arraignment, the district attorney makes a motion to prevent removal. If defendant fails to report to probation as directed, such period shall be told until such time as he or she reports to probation department. 11. 722.23. A motion made by the district attorney to prevent removal to family court shall be made in writing and shall be on prompt notice to the defendant. So there is no actual day time rule there. It's prompt notice, and the defendant shall be given any reasonable opportunity to reply. So that's why the answer was none of the above. 722.23. If the DA makes a motion of, let me see if I can stand. 12. If the district attorney makes a motion to prevent removal of an action against an adolescent offender to the family court, either party may request a hearing. ... The hearing shall be held expeditiously. Now, that was a mistake on this test. It's supposed to say adolescent offender because you're in 722.23, and the motion to prevent removal is only about the adolescent offenders. So that is a mistake. Question 13. If a hearing pursuant to question 12 is held, A, there shall be a presumption against custody. True. B, Case planning services shall be made available to defendant. True. C. Court shall make a determination in writing or on the record within 5 days of the conclusion of the hearing or submission by defense, whichever occurs first. No, last? Whichever occurs last. Whichever occurs last. Or submission by the defense, whichever occurs last. And the answer was all of the above. Question 14. Upon arraignment of a defendant charged with a crime committed when she was 16 or commencing October 1st, 2019, 17 years of age, of a Class A felony or a violent felony, the court shall schedule an appearance no later than 6 calendar days from such arraignment. So, the only thing this doesn't apply to is a drug felony. 15. The purpose of the appearance described in question 14 is D. For the court to review the accusatory instrument and any other relevant facts for the purpose of making a determination regarding removal to family court. Question 16. The defendant may waive review of the accusatory instrument by the court and the opportunity for removal in accordance with 722.23, but such waiver must be knowingly and voluntarily made in open court in the presence of and with the approval of his or her counsel and the court. 722.10. Judges of the youth part, as well as judges authorized to preside as accessible magistrates, shall receive training in specialized areas, including but not limited to 1. Juvenile justice, 2. Adolescent development, 3. Custody and care of youths, D. Effective treatment method for reducing unlawful conduct by youths, and the answer was all of the above.